everyone, this is Gilbert Gelano. I'm talking to you here from Private Corporate Counsel. This is Tufts On Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts, the expert and the master when it comes to taxes. T. Scott Tufts, how are you today?
Good to be with you.
Good to be with you too. Now, folks, you can call him at 877-647-7887, or you can email him at stufts@pcc.law. That's stufts@pcc.law. And that number also can be on a 407, which is 407-647-7887. Now, Scott, today we are talking about backdating versus documenting what happened. So what is that supposed to mean, and if you can clarify on that?
Sure. So the concept of backdating would be something that our audience, you might hear out there. It has a pejorative concept to it because by that we mean, are you engaged in something you shouldn't be doing? Okay? Mm-hmm. And what we're talking about in particular are events or circumstances where the document in question or the events that are occurring, there's an effort underway to say it happened yesterday instead of today, for example. So you've got to look at documents when you sign them and look carefully at what it represents as to when it's being signed. And, we kind of fly through life sometimes and we don't think how important little words might be. But if you sign something that says this, the blank day of blank, and you're representing when you sign it that it was signed on that date, and it is in fact not that date, then you have to then ask, well, why is there an effort underway to sign it? Now, a lot of times folks will be innocent, if you will, or not really focused on what day it is or whatnot. But other times they may. And when you are talking about taxes like we do, and you get near the year end, as we're kind of coming along here, we're in October, and we get near the end of the year, tax transactions go by what year they occurred in. They occur in the current year. So we start thinking about this concept, and it can come up in cases. And again, the situation's going to be, let's say we've talked about operating agreements, for example, and we've talked about how they, two LLCs can, or two people can get in an LLC or more, or whatever the number of members are, and you could be up and running and have a handshake and have no written operating agreement. But let's say you have an understanding of how you're going to operate, and you do that for 3, 4, 5 years. And then we say, well, let's get it in writing. What happens if you have a draft and you haven't signed it yet? Well, us lawyer types know that it's kind of important to know whether or not what you're describing is something that's already been agreed upon and been and we're attempting to put it in writing. How many deals, Gilbert, you can imagine might occur where folks put together their deal, and then they go to the lawyers and say, all we need you all to do is put it in writing. Well, it's on a napkin, or it's in the just discussions. Well,
which is sad. I mean, it's
not
unfortunate.
Not prudent, but it can be done, and has been done, and is okay to be done. What you can't do is attempt to take a situation and purport to describe it as having happened prior when it did not. That's when. So when you hear the term backdating, the first question to ask is it really a backdating situation? Because it may not be. It may be very above board situation where the lawyers are drafting a document and attempting to memorialize that which already occurred. Okay? But if it's not that, and it's attempting to say this happened 3 years ago in October of 2020, and it didn't happen, and we know that, and yet we're putting together a document that purports to do that, then there can be problems. And so that's what happens. So let's talk about what happened in this tax case that came out in August, Lakepoint Land 2 LLC v. Commissioner. So again, with the idea that our audience may say some of this stuff doesn't occur in real life, right? Taxes are complicated. Nothing, these things don't happen. We're trying to tell the audience, yes, they do. Another thing that I hear sometimes, Gilbert, is that somehow these courts and tax court are not a fair playing field, right? Not a, it might, the concern would be that, hey, it's the United States tax court, you can't get a fair shake there or whatever. I mean, I don't know that I hear it that much, but let's assume someone has that worry or concern. What Lakepoint Land tells us is, you can be encouraged. Well, you can be discouraged by what I'm about to tell you happened in the case, but you can be encouraged by the fact that the court did not like what happened, and no matter who the lawyers are that appear before court, this kind of case reminds us why backdating is a serious problem. And then, Gilbert, when it comes out, you better not try and cover it up or be less than candid about it. So let me tell you what happened. So Lakepoint Land is a case involving partnership LLC entity that is under the old TEFRA rules. Remember, this is what we've talked about with a tax matters partner that got changed over. Now we have what we call BBA partnerships and partnership representatives. But putting that aside, what the point being is that an LLC gets audited, and they're looking at the results of that audit, and what the focus becomes is the audit is going through, and then they're going to look at penalties. And in the IRS world, there's a law that requires, in order for you to be penalized, it has to go through an immediate supervisor of the revenue agent. It has to get approved by a supervisor, okay? So think about what I'm saying. You're going through an audit. The agent diligently goes through the material, comes up with an audit, has some adjustments for your return, okay? But they feel like you should be assessed a penalty on top of the taxes. They have like what we call an accuracy-related penalty or even a fraud penalty. But in order to initiate those penalties, the law in its section 6751, subpart B, requires a supervisor of that agent, the immediate supervisor, to approve that process. Okay? So what happened in Lakepoint was they did not, it was important in the processing of the penalty to establish that it was properly presented. So when you're litigating tax cases and we're looking at how they went about it, you can imagine you'd say, okay, how did you initiate the penalty? At what point did you initiate the penalty? And you'd want to see that it was properly done. So a lawyer in my kind of situation representing someone, I would be looking at, was the penalty properly initiated? So that's a procedural issue, right, Gilbert? Mm-hmm. It's saying, has it gone through the proper steps to be initiated? And in this case, they got the case settled and resolved with the idea that the penalties were properly initiated because that's what the government represented. Got it? However, come to find out, they did not have it properly approved in the way that they were representing to the court. Okay? So, in other words, the court was led to believe that the penalties were properly initiated with the supervisor's signature at a certain point in time. And then they proceeded to win the case on that basis, based on the representation that they did the penalties correctly. Got it? Mm-hmm. In order to show that, they had to present what we call lead sheets. And this would be nothing more than a log of your activities, if you will. So the government does this in cases. So if you're litigating a case with the government and a tax court or in any, or in the refund litigation, you're going to want to obtain these kinds of internal documents that show what happened in the development of your case at the audit level. Got it? And when you get the audit level details, and you are looking at things like the lead sheet, and you're going to look particularly for penalty approval, you're going to look at, was it signed off on? All right, so the bottom line is what they did here is they presented a document that purported to show a signed off supervisor's signature as of a certain date. Got it? Mm-hmm. They then obtained the result.
Was it the
lead
true,
sheet?
The true date? Or?
No. So what happened was it comes out that the lead sheet was backdated. So the IRS, in the context of presenting this information, someone got into the situation where the supervisor's signature had an earlier date on it than what came out. Okay?
That's unethical.
Right. But it gets worse because when they had the chance to, when they were presenting the information to the court, right, the lawyers are presenting that as being accurate as well.
Wow.
So what happens is that when this all comes to light, the taxpayer's lawyers present the argument that the court should reconsider, right, what happened, right, because the penalty wasn't properly initiated, okay, and therefore it was false evidence presented to the court, okay, and they moved for sanctions against the government and the government's lawyers.
Wow. So
the point being that this is kind of, right, and remember, the government didn't just say, okay, they didn't step up and say, hey, you got us, or any kind of mea culpa. The government said, hey, wait a minute, okay, this happened, we're sorry, but it's not that, they got an explanation. Oh, we put the date on by accident, or whatever. You follow me? So it wasn't like they came back and said, oh, we agree with you, this was false. Like you can imagine in a backdating situation, someone might say, oh, I put down a 5 instead of a 6, or no harm, no foul, right? What's the big deal? You might get that. Yeah, okay, you should have put the current date, not the date, some other point. You see what I'm saying? So the court got to hear that kind of argument where the government says, okay, but no big deal. Not bad faith. No, nothing, we're not trying to, put one over. And the point is the court said, not so fast, because you as attorneys have to, you have a duty to have some candor before the court, and that includes the representations that you're making. And when the parties were learned to have discovered it, Gilbert, then it's really time to have candor, right? So when this was brought up, right, the other side shouldn't be making excuses. They should be fully, in the court's eyes, coming forward with what happened, and right? Mm-hmm. And if you're the attorney, you can't cover for your client and make a bad situation worse. Got it? So they all get sanctioned. The government gets, their case is now in trouble when they otherwise had a good result with the penalty approval. Now that's coming undone, and they've got to deal with, okay, we've got to deal with that, right? The penalty wasn't properly initiated under the rules. But now we've got a greater problem. They've got sanctions coming. And the court uses its authority to sanction because it finds that the declarations that were provided attesting to that date were false. So at the end of the day, the court rejected the idea that this was harmless error, or whatnot. They did not require bad faith, meaning it wasn't that, hey, you meant to do it or anything like that. It was that they expected more of the attorneys before the court, okay? So what I'm getting at here is that whether it's the government side or the taxpayer side, us attorney types for the government and for taxpayers have to, when we're presenting information, be very careful. And in this context of backdating, if a date becomes important, start to think about it. Look at those details and do not gloss over them either in your investigation forensically. And if a date matters and they almost always do in the tax world, dates do matter. And then the next question is, if you sense that backdating is occurring, and again, backdating would be a date when something actually happened is different from what's represented on the document. Okay. Yeah. And so, there's all kinds of cases that talk about things like, well, like Gilbert, you go to make a gift and you're getting near the end of the year, and the gift is made in January, but you were kind of getting around to it in December. Might not want to say it happened in December if you didn't get around to it until January, when it actually happened. See the difference?
Yeah.
So I think, again, and then the other thing...
Very important.
Yeah, so I think so the concept here is, when you're documenting something, don't be scared, don't be, wary, but pin down exactly when something occurred and try your best not to have something be a misrepresentation. And I think our audience needs to be aware of one term you'll see a lot in legal documents is effective as of. And you need to look when you see effective as of a certain date, right? That's usually a sign that it's saying that we're going to say that this is effective as of a certain date that's not today. You see what I mean? And so you'll see a lot of documents that have an effective date. And that could be in the future or could be in the past. If it tries to be effective as of a date in the past, make sure that those representations are as accurate as possible as to what happened, or that you understand the document. If you're not clear, ask the questions you need to about whoever's preparing the document or whoever's involved in the transaction, what's going on. Okay?
Like you said, always put the correct dates when you're documenting.
Yeah. So our audience, when you see a date, especially we see this a lot in wills and estates and all that. If you're representing, take pride and honor in your signature and your date, but also watch the date itself as to what you're holding out as when it occurred. Very important. And life goes fast. And and again, this is not to suggest that if a date's wrong, that it's the end of the world. It would be that just get your guard up, make sure you understand it, try and pick up, try and be vigilant, and try and avoid mistakes, right? I mean, dates can get on there the wrong date. I mean, this happens a lot when you get around January of 2024, you're still using 2023 because you're not flipped over to the new year yet. I've seen that a lot. We all make the typos and stuff like that. So again, mistakes can happen, but be very careful with the effort to backdate when backdating means doing something and saying something happened when it didn't. Okay?
Absolutely. Great advice. You heard him, folks. And if you have any questions or any concerns about this topic or any case that you are in, contact Mr. T. Scott Tufts at 877-647-7887. Again, that number is 877-647-7887. That will be reached also on a 407 area code. Email him on stufts@pcc.law. That's STUFTS@pcc.law. Thank you and have a wonderful day.